Hi, everyone. Harry here to talk about an important development in another part of this whole dispute over the administration's efforts to deport members of a transnational crime organization, or at least they so allege, down to El Salvador or out of the country. There are about 350,000 Venezuelans in this country who have a certain authorization to work called TPS, or Temporary Protected Status. And the Department of Homeland Security was planning to just strip them all of that temporary protected status, presumably in an instance of the ridiculous overkill, in order to be able to get at anyone whom they think is affiliated with the Tren de Aragua drug organization, which, as you probably remember, in another part of the case, they have fought to deport and have deported without any due process a few hundred. All right, but separately, this is a lawsuit against the Department of Homeland Security and a Judge Ed Chen in San Francisco, my old stomping grounds when I was first in AUSA, has entered a restraining order preventing the Department of Homeland Security from taking away this TPS or protected status. And it's a really sort of emphatic, strong opinion that's also a very strong repudiation of what the administration was trying to do. So it's like 78 pages, and let me just, cut to the chase on his core conclusions. He freezes the effort by the Secretary of the Department of Homeland Security, that's technically in whose name the legal action is taken, threatens to inflict irreparable harm on hundreds of thousands of persons whose lives, families, and livelihood will be severely disrupted. Certainly true. So many people are here, make money, send it home, and this could put them in a real sort of unprotected zone that would threaten their work. And it could cost the United States, he says, all this money in economic activity, although that typically wouldn't be a part. That would be a part of the sort of last factor in granting a stay, the balance of equities and the public interest. Also injure public health and safety in communities throughout the United States, which is, one of the arguments that they were able successfully to advance. But here's the big thing. As he puts it. And this has really been true top to bottom, and what made so outrageous the administration's spiriting away in the night to either knowingly or even unknowingly get ahead of the district judge, Judge Boasberg's countermand, which is they could have waited. The only reason they didn't wait is to not get a ruling from a court that, hey, you're violating the law and violating due process. That's not a compelling reason not to wait, especially when the consequence of going down so quickly is the essential, ultimate Kafkaesque horror of disappearing at least one person the U.S. has admitted, and allegedly more than that, who've just been improperly, not even members of the gang, put on a plane, sent down to a hellhole of a prison. It's more like a concentration camp, there to remain, perhaps indefinitely. The United States, as he has said, there's no power to bring them back. Of course, they should be exercising every possible diplomatic prerogative to bring them back, including giving El Salvador, where they are, whatever it takes. But instead, they throw up their hands and say, "Oops, no power. Gotta break a few eggs to make an omelet." But so, at the same time, says Judge Chen, the government has failed to identify any real countervailing harm in continuing TPS for Venezuelan beneficiaries. And that's the strong and important argument is, what's your rush, pal? why administration can't you simply permit the legal process to run its course? So that he grants the stay, and as you may know by now in your perhaps involuntary intense primer on legal stuff, including international. The number one thing you got to find first in order to enter a stay. This is in the USAID case. What the district court found and the Court of Appeals just reversed is the plaintiffs are likely to prevail. And Chen indeed finds they're going to likely succeed in demonstrating that the actions taken by the secretary are unauthorized by law. So it's the immigration system such as it exists doesn't permit this kind of willy-nilly stripping of TPS. Indeed, this may be the first time that TPS has actually been stripped away. In any event, it's very, very rare. But in addition to that, they violated the Administrative Procedures Act, and what that means is they acted arbitrarily and capriciously, and that this just seems the definition of it, right? A very abrupt pooling of status for 350,000 based also, and here's the third point that the court is making, that the reasons the plaintiffs are likely to succeed as an unconstitutional discrimination against a particular nationality. So that seems a problem too. So to do it creates a lot of irreparable harm and the like, but the main thing the court's saying, and you can expect the U.S. to appeal this probably to the Ninth Circuit, is the plaintiffs are really stand to win here because under the Constitution, they're singling out a particular group, but also under the Administrative Procedure Act, they've acted arbitrarily and capriciously. So that's what we'll see as the case goes forward, but a really strong rebuke of the administration by a district court judge. And again, on the other side of this dispute where they've just tried to pool temporary protected status from hundreds of thousands of Venezuelans. So that's separate from the whole challenge to the deportation of a few hundred. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.